U.S. Representative Roybal Allard. We don't expect to see any movement on the federal legislation in the current Congress. However, even without a change in federal law, there are still many things that can be done to help detained and removed parents preserve their relationship with their children. We hope that the strategies discussed today will help you in this effort. Now let me turn it over to Rachel Jordan for a quick note about logistics.
Hi, everyone. This is Rachel Jordan at the Women's Refugee Commission. I just wanted to tell you a little bit about the webinar. Currently, all the attendees are on mute. We've set aside some time after the presentations to ask questions. We'll provide more instructions at that time about how to ask a question. Given the large number of people on the call, we will not be using the webinar's chat function. You're welcome to email any of the presenters following the webinar with additional questions. Emily Butera at the Women's Refugee Commission can put you in touch with them. And if at any time during the webinar you are suddenly disconnected, please just wait for 5 minutes and try logging back in. Sometimes that happens.
Thank you, Rachel. Now I'd like to turn it over to our first presenter, Seth Wessler from the Applied Research Center, who will discuss the latest data and trends on immigration enforcement.
Thanks very much, and thank you everyone for joining this webinar today. I'm Seth Wessler from the Applied Research Center, a racial justice think tank, and we're publisher of Colorlines.com, a daily news site on race and politics. I'm a researcher and an investigative writer here. For the last decade, we've been hearing stories about families who have been torn apart by deportation, and in some of those cases, detained and deported mothers and fathers have lost their kids to the foster care system. I first wrote about a story like this about 5 years ago. A Russian mother was detained in a detention center, and her U.S. citizen child was placed in foster care. And the family court judge was clear that this mother should be reunified with her daughter, that they should be back together. But the mother remained in detention, and she could do nothing to move toward reunification. Once she was deported, there were no efforts to reunify her child with her, and the baby was put up for adoption. Likely they will never see each other again. Half a decade later, things have gotten worse, and ARC, the Applied Research Center, undertook to investigate the extent to which children are stuck in the child welfare system and face barriers to reunifying with their parents who have been detained or deported by federal immigration authorities. As many of you may know, the country is currently deporting historic numbers of people, and as a result of those historic numbers of deportation, 400,000 a year, as well as rigid detention policies, combined with a lack of clear policy in the child welfare system to reunify families separated at the intersections of child welfare and deportation. Families are often permanently separated or separated for extended periods of time. The Applied Research Center last year began work on a national research study to explore the extent to which there are children in foster care around the country who face barriers to reunifying with their mothers and fathers. We issued a Freedom of Information Act request to the federal government, and we found that in the first 6 months of last year, 46,000 parents of United States citizen children were deported. We wanted to know how many of their children were in the child welfare system. Based on surveys and data collection from counties around the country, from key counties and key states around the country, the Applied Research Center estimates conservatively that there are over 5,000 children who are in foster care in states around the country who face barriers to reunifying with their mothers or fathers who have been detained or deported. If current levels of deportation and entrance into foster care remain the same over the coming 5 years, 15,000 more children will enter into the same situation. What we found was that this is not a problem that is isolated to states on the border or necessarily with particularly large immigrant populations, but it's a national problem that's emerging all over the country. In the year of our research, we found instances of such cases, cases where children were in foster care and faced barriers to reunifying with their parents in 22 states, and since then we've heard of cases in more states than this. It is a problem that is expanding outward from the border into the interior of the United States and is affecting families all over the country. Part of what we were trying to figure out in our report, which you can find in full at arc.org/shattered families, was what factors contribute to high levels of children, large numbers of children in the child welfare system with detained and deported parents. And one of the things we found was that in communities where local police participate in immigration enforcement, families are put at risk of being separated by immigration enforcement and the child welfare system. So for example, foster children in places where the 287G program, which is a long-standing ICE program that authorizes local police to act as ICE agents, in jurisdictions around the country where police act in this way, where they act as ICE agents, foster children are nearly 30% more likely to have a detained or deported parent than in other places. And this is true even when controlling for the immigrant populations in those places. This is important because Secure Communities, a different and newer program, is now spreading rapidly around the country and is soon to be operational in every jail in every county in the United States. I want to talk a little bit about the different pathways that families take or are put on to arrive at a situation in which parents have been detained or deported and children are in the child welfare system. There are many different scenarios. Every family is different and every case is different, but I want to talk about three sort of kinds of cases. The first kind of case are cases that I describe as straight paths to separation. Cases in which parents have been deported, and as a result of that deportation or detention, children enter into the child welfare system. The slides are moving a little slowly here, so forgive me. While I wait, I'll tell you about this without the slide. I want to give an example of a case like this. A children's attorney told me of this case. In the case, a mother was picked up, the children's attorney described to me, a mother was picked up on minor charges that were entirely unrelated to her children. And the attorney said, considering the nature of the minor allegations, had she been a citizen, the children she would have bonded out in a day, and the children would not have been placed in foster care. But as a result of her detention and subsequent deportation, the children had no place to go and were placed in the child welfare system. She remained across the border, and the children remained in foster care for months at the time that I talked to the family. We uncovered many cases in which there was a straight path, a direct relationship between immigration enforcement and children entering in the first place, entering into the child welfare system. The next kind of case that I want to talk about are cases that follow a parallel path in which the child welfare case and an ICE case, an immigration case, start at the same time. We heard a lot of cases, particularly disturbing cases, in which women were detained as a result of after they were charged criminally when they defended themselves against abusers. And in one such case, a mother was arrested for assault after she tried to defend herself. After her arrest, as is often the case, the child welfare system was called and removed the children and placed them in foster care, in temporary foster care. But rather than being released, this mother was moved into detention because of that assault charge related to her self-defense related assault charge. And the children remained in foster care. At the time that I interviewed her inside of a detention center, she had very minimal contact with her children. And then there are cases, the next kind of case that I want to talk about are cases in which families are already involved in the child welfare system. And these are cases I describe as interrupted path cases, in which the path to reunification that most families move forward on when they're involved with the child welfare system is interrupted by the detention or deportation of a parent. So in one case, a green card holder from Portugal and her US citizen son were weeks away from reunifying when she was detained after stealing clothes for her son. She was arrested by local police for petty theft, and the officers drove the child back to the foster home. The mother was then placed in deportation proceedings, and the reunification process was stopped. Had she been a citizen, it's unlikely that that reunification would have been entirely derailed. It's important to recognize that these cases take different shapes and look differently. But as the panelists moving forward will describe, there are a lot of things that that can be done regardless of how families end up in this situation in the first place to ensure that families can remain together and are reunified. I'll stop there and pass the presentation on to Lindsay.
Thanks, Seth. Next, we have Lindsay Marshall from the Florence Immigrant and Refugee Rights Project, who will discuss tips on how to keep children of detained or removed parents out of the child welfare system and how immigration attorneys can assist their clients with child custody matters.
Great. Thank you, Wendy, and thank you, everyone, for joining this webinar. For those of you that aren't familiar with the Florence Project, to give a little bit of background, we are a legal service provider. We have a legal orientation program subcontract, and we work with parents, men and women that are in immigration removal proceedings here in Arizona that are detained in either one of 4 facilities in Florence or a large facility in Eloy, Arizona. And then we also work with unaccompanied children who are in custody and going through removal proceedings in Phoenix. So we have some expertise in special immigrant juvenile status. We've had some interaction with the family court that way. So our focus is on providing deportation defense services, primarily by assisting people to appear pro se. But obviously we are encountering a lot of issues with parents that are concerned about child custody issues, and so have been kind of getting more involved in that area with assisting parents. So this section of the presentation is intended to kind of be practical and to give you some tips and some things that we have worked on here over the last couple of years to kind of overcome these challenges to keep families together. And it's kind of based on our experience here in Arizona. So first, one of the things I wanted to emphasize is something that we've realized is that as a legal service provider, as an immigration attorney or an advocate or a volunteer, it's helpful to think of yourself as kind of a first responder when it comes to these issues of flagging whether there is a child custody issue or an issue where parental rights might be in jeopardy. Despite announcements that we hear about kind of a kinder, gentler immigration enforcement system, I think most of us know that obviously families, as Seth explained, are getting caught up in this system, and so it's important not to sort of assume that ICE has flagged any child custody issues or that the child welfare system in your state is aware of where parents are. It's best to just kind of assume that nobody knows and that parents are usually pretty lost in this system, and that you, if you're getting involved, might be kind of the only one that can kind of make these connections. And we try to sort of think of ourselves that way. If you are in a role of being a legal service provider, an immigration attorney, or you're working with parents that are in ICE custody, one of the things that we've started to do is to try to flag whether there are child custody issues. Just to give a bit of context, we're working with, kind of close to 9,000 people each year, and so when we're doing our work, we're doing a Know Your Rights presentation to anywhere from 40 to 80 people, and then we have very quick intakes of people, but we've been able to start to flag whether there are some of these child custody issues through that intake. So some of the questions that we ask people, in addition to questions that we're trying to figure out whether they're eligible for immigration relief, would be, do they have minor children? Where are those children living? How safe and stable is this living arrangement? So the answer might be yes, they're with my neighbor, but I'm not sure how long they're willing to take care of them. Or They might be with the other parent who might be abusive. So trying to kind of get at a little bit more about kind of where the kids are and whether that's kind of stable and potentially dangerous. And then also asking about whether the family has had any involvement with the child welfare system, whether Child Protective Services or the equivalent agency in your state has been involved with the family in the past, can be helpful to flagging these issues. And then to kind of reiterate some of the limitations for parents when they are in detention, and I know Emily's going to touch on this a bit when she's talking about strategies as well, but some important things to know about the detention system, if you don't already, is that they tend to be in more rural locations. People are not necessarily going to be detained in the state where they are from or nearby. They're very isolated. These are prison jail facilities. Phone access, people have to have money on their books in order to make phone calls. Visitation can be quite limited. Mail systems are often problematic. We have a lot of parents telling us that, or we have a lot of people in the child welfare system, if there's a dependency action saying they've mailed things to parents, but parents don't get them in the mail for the facility. So that's a good assumption, is that mail can be problematic. The length of detention is often indefinite, and it can really depend on what's going on with their deportation case. There are obviously challenges to access to counsel if there isn't a legal orientation program or legal service provider serving that facility, then that becomes even more acute of an issue. And also the detention is civil and administrative in nature to ensure people are present for their immigration court hearings. So there is no, there's a lack of, I have to say, of programming in facilities, at least in the ones we work with, which poses a lot of challenges when you're talking about a dependency action where there are case reunification plans that need to be in place. So all of these things are just good to be aware of and keep in mind when working with a parent in custody or working on a case where you know a parent's in custody. So the last two slides, this one is talking a little bit about how we have and how I would suggest supporting parents who are kind of navigating the child welfare system while they're in detention. One of the things that we're trying to focus some more attention on through community collaborations and collaborations with pro bono attorneys in Arizona is to try to work on some preventative measures in order for families to plan if one of the parents does get put in immigration custody, and ways to sort of preserve family unity. And these vary by state. Here in Arizona, we have something called a Title 14 guardianship, where families can make arrangements for a relative or a trusted friend to take over parenting decisions for a certain amount of time. And these are documents that can be executed so that if someone does end up in custody, this can kind of avoid potentially the child welfare system getting involved long term and kids going into foster care. And then there are also powers of attorney, and I would encourage you, if you're not already aware of ways in your state that parents can make some of these long-term plans so that it can kind of avoid dependency actions in the first place. And then if that doesn't happen, which in most cases we're working on, that hasn't happened, really our role has been to help parents in detention kind of navigate through the child welfare system. So we kind of think of it as sort of connecting people and connecting the dots. So often we'll go out and meet with a parent who knows their kids are in foster care, and then we'll ask them, well, do you know who the Child Protective Services case manager is? Or if you have an attorney appointed to you, do you know who that is? And trying to kind of make phone calls to those people, that's probably the first most important thing that we do to inform them of where the parent is located, and kind of just acting like communicators and connecting those different parties so that the parent isn't lost and excluded from decision making about their children, or excluded from dependency actions if those take place. And then this final slide, or the other kind of shift of that, is sort of how to support parents in the immigration component. We are immigration lawyers and focusing on the removal case, as I said, so we're trying to think more creatively about bringing this issue into the realm of deportation defense as well. So one of the things that we try to push, and we, to be honest, haven't had a lot of success with this, but I think depending on your jurisdiction you might, and nationally I think it's something that we're making some progress for, is trying to kind of raise the profile of parents that are in these proceedings that have U.S. citizen children, and saying that these are grounds for either prosecutorial discretion or administrative closure of somebody's case, or release on parole, so release from detention so they can participate in the child welfare system, or having an alternative to detention, something that's less restrictive so they can, still be taking care of their children and be a part of proceedings. Usually if it's an urgent situation, if the kids are in foster care, if the case has been going on for a long time, we try to stress this, and we've had a little bit more success in those cases where termination of parental rights might be imminent. And then just kind of more broadly, just trying to document these cases through work that Seth and Applied Research Center has done, and as well as Women's Refugee Commission, but trying to kind of create some more kind of accountability both locally and nationally about the types of people and the parents that are in these proceedings. And then another thing that I would recommend doing that we're trying to do a little bit more of as well is pushing this issue in front of the immigration judge when people do have removal proceedings. For bond determinations, flight risk is one of the factors that are considered. So obviously somebody's U.S. citizen children and their capacity as sole caregiver of those children is relevant to flight risk, and also can be relevant in a discretionary decision about whether someone should get released from custody and what and how high their bond should be. So we're trying to kind of more consciously raise that and advise parents to be bringing that up when they're seeking bond, if they're eligible for bond. And then cancellation of removal is a form of relief for lawful permanent residents or people that are undocumented that have lived here for a long time. And they're one of the few forms of relief where there's discretion for the judge to consider some things such as ties to the community or hardship on U.S. citizen children. So one of the things we're trying to do more of is kind of more thoughtfully raising this issue in those types of cases. And I think depending on your jurisdiction, you could have some success there. So I'll stop there. These are just, I think this will segue nicely into kind of the broader topics that Emily's going to talk about that relate to working with parents that are in custody. So thank you.
Thank you, Lindsay.
Thank you, Lindsay.
Now I'd like to turn over to Emily Butera at the Women's Refugee Commission, who will speak about strategies for preserving family unity when parents are detained or removed and children have been placed in the care of the child welfare system.
Thanks, Wendy, and good afternoon, everyone. I'm going to pick up where Lindsay left off, as she said, by talking more specifically about strategies for preserving family unity when a parent is detained or removed. And I just want to preface my slides with a couple of caveats. One is that the tips that I'm going to go through are based on the kinds of cases that we've seen so far. Certainly there are thousands of different scenarios that can play out with these cases. So if you've tried the techniques that I'm talking about and they haven't worked, or if you've had some other strategies yield success, that information would be really helpful to us, both for educational and advocacy work. So I would encourage you to get in touch with me with any feedback you might have. And the second caveat is just, I know we have some folks on the line who have a child welfare background. I've used very generic terms to talk about the child welfare system and child welfare processes, since we do have a very broad audience on the call today, but hopefully it will still be translatable for you on a broader conceptual level. So with that, I will go ahead and get started. And the first thing that I wanted to address is an area where we see a tremendous amount of confusion, particularly within immigrant communities, and that's regarding the rights of undocumented parents. So all parents in the United States have legal rights to their children. That's what we mean when we talk about parental rights. And this includes the right to make decisions about the care and upbringing of children, and also the right to live with children. At the same time, parents have responsibilities, including to ensure that children's basic needs are met and that children are safe from harm. Parental rights can be temporarily taken away if the state does not think that children are safe with their parents. And those rights can be permanently taken away, but not until the state follows certain established procedures for doing so. One of the common rumors that we hear from undocumented communities is that U.S. citizen children are the property of the U.S. government. And therefore, if a parent is removed from the United States, their children must stay behind. And in fact, the U.S. government automatically has an innate right to keep those children here. That is not true, as I'm sure most of you on the call are aware. But to the extent that you can dispel that myth in immigrant communities, that would be extremely helpful. In terms of preservation of family unity, obviously one of the best ways to keep a family together is to keep the parent out of detention. And Lindsay talked about some of those strategies. I think they're really important, so I'm just going to emphasize them really quickly. As soon as a parent is apprehended, either the parent or you, if you're in a position to assist or be an advocate for that parent, really needs to think strongly about telling ICE there are children involved. I know if the children are undocumented or the person who's caring for them are undocumented, that can be a risk, and it's a risk that every parent needs to decide to take, fully understanding the potential for other members of the family to be caught up in the immigration system. But there's nothing ICE can do to keep a family, keep a parent out of detention and in the community with their children if they don't know that there are children involved. As Lindsay said, you or the parent want to be sure to ask ICE to exercise prosecutorial discretion and also ask ICE to consider not detaining the parent. There is straight release. There are also all sorts of alternatives to detention that can be used to ensure that somebody is complying with immigration proceedings but does not have to be in custody. The parent or somebody who's assisting them should also make sure to ask ICE as quickly as possible whether they can make phone calls to make childcare arrangements. There is currently no formal ICE policy that allows somebody to make calls to make childcare arrangements, but there's also no policy that bars that, so it really doesn't hurt to ask. If you've tried all of these things and ICE decides to detain the parent and does not exercise discretion, both you and the parent want to keep raising childcare concerns and asking for release at every stage of the process. When I'm talking to parents who are in detention, I always tell them to tell every ICE official they talk to that they have kids and ask to be released. And certainly if anything changes with the child's custody or safety, and a common scenario in that regard is that a mother often is in custody and the children are with her partner who may be an abuser, you want to make sure you're telling ICE. As Lindsay said, sometimes the agency is willing to reconsider requests for release based on urgent humanitarian situations in the community. So, a common question is, how do I know if children are in the child welfare system? If nobody was available to care for children, so for example, if they were left behind at a school or with a babysitter, or if a parent was not given an opportunity to make care arrangements of their choice at the time they were apprehended, those children may very well be in child welfare care. And the sooner a parent or somebody who's helping them tries to answer that question and establishes contact with child welfare, the better that will be for the long-term potential for family unity. So, as Lindsay talked about, it can be very difficult for a detained parent to make phone calls. If they can make a phone call, or you or a family member of that parent who is in a position to do so, can get a start on contacting child welfare, that is certainly the best way to go. There is a list on the Women's Refugee Commission website at the link that I've provided in the slide here for the child welfare hotlines in all 50 states. There's also an organization called Child Help, and you can see the phone number on the screen. That organization can link you to any child welfare agency in any county in the country. So get that call in as quickly as possible. When the call is made, you want to be sure to give the parents and the children's full name and inquire as to whether a case has been opened. If so, be sure to note the name, the address, and the phone number for the child welfare office, that's the specific office where the case is on file, the caseworker assigned to the case, and any attorney, guardian ad litem, or advocate who's been assigned to the child. You also want to ask for and make a note of the case number for each child's case. So if there's a family with multiple children, they're all going to have a different case number, and you need to capture that. Similarly, when you're on the phone with a hotline worker, you want to ask them to add the parent's name, any name under which they are in immigration detention, which oftentimes is different, their A number or their alien registration number, and the address of the detention facility where they're held. It may be difficult to get in touch with child welfare, so just kind of know that, and as you're making the phone call, know that it may take some persistence to get through. Obviously, to the extent a parent has an attorney, it can be a huge help for their ability to preserve their parental rights. Now, note for those who are not child welfare folks that not all states appoint attorneys for parents. Also, even if there is an attorney appointed, oftentimes those attorneys are not familiar with the immigration system, so they may not know how to locate their client, or they may struggle to communicate with them, especially if the parent is detained in another state. I can talk a little bit about strategies for locating a parent at the end. But in the meantime, if no attorney has been appointed, you can ask the judge, or the parent can ask the judge repeatedly. Be sure to ask in writing, and be sure to ask at every hearing. It's always better to use the state-specific form to request appointed counsel, but if you don't have access to that, there's a sample form, again, on the Women's Refugee Commission website that you can use to request counsel. If there is a possibility of securing a private attorney or legal services provider, legal aid, a law school clinic to help the parent, oftentimes for the reasons I described above, that can lead to a better outcome. If there is no attorney in particular, and you're in a position to try to help a parent navigate the system, make sure that you're communicating any change in the parent situation to the family court, the child welfare system, and any attorneys who are involved. And that includes, is the parent transferred to a new detention center? Are they released from detention? Are they removed from the United States? And a common theme that you'll see on the slides here is you and the parent should really be keeping copies of any correspondence with the child welfare system or the family courts. For a parent who's detained, they may not have access to copiers. That may mean that they actually have to handwrite copies, which I know is a real burden. But everything that they can do to establish both their interest in reunifying with their child and everything they've done towards that end can be very, very helpful if the case moves to termination proceedings. So, as folks on the call have intimated, anytime a child is in the child welfare system, there's a case plan that's assigned. And the case plan is things that a parent needs to do as a precondition to reunifying with their children. Detained parents have a right to participate in the child welfare case plan, even if they are detained, and child welfare should be helping the family, and particularly the parent, to work that plan. But obviously, the experience of being detained and removed can cause a lot of complications, as Lindsay talked about. You should know that all detention facilities have a visitation policy. You can call the facility to ask what it is. You can also sometimes find it on the facility's website. And that will establish hours for visitation. Now, visitation may or may not be contact, and it requires somebody to bring the child, which may be difficult if the parent is detained out of state. Now, the one very important thing to keep in mind here is that if the child or the person who's caring for them would be bringing them to visitation is undocumented, they should absolutely never enter a detention center because they would place themselves at risk of being put in immigration proceedings. As Lindsay talked about, phone calls are an option. They can be a challenge. If a case plan requires things that parents cannot do, the parent or somebody like you who's assisting the parent can ask child welfare to amend the case plan. Some things you could think about are if the case plan requires contact visitation and it's only non-contact visits, can be amended to say non-contact visits. Could phone calls replace visitation? Could the parent draw pictures instead of write letters to the children if they're, for example, illiterate or can't communicate in the same language that the child speaks? Of course, just as case plan compliance is difficult, it's extremely difficult to participate in family court proceedings, but any detained or removed parent has a right to participate in those proceedings. While there is not yet a consistent established protocol on the part of Immigration and Customs Enforcement for requesting to participate in family court or any other proceeding, there is language in ICE's new performance-based national detention standards. That's the 2011 standards. You can find that at Part 5.2. Now, those standards are not in place at most detention facilities yet, and they will be rolled out over the next year or so. But even if those standards aren't in place at the facility where a parent is detained, you can still kind of point to that as a policy or procedure that ICE could follow to get that parent into court. So as soon as the parent receives notification of a family court hearing, they need to show that notice to ICE, and they need to ask to participate either in person or by phone. It could take several weeks to make that happen, so you really want to make that happen quickly. And you should also note that under the standard, a parent could be required to pay their own transportation costs to family court proceedings, so obviously that's something that you need to take into account. If a parent requests that ICE facilitate their appearance and ICE will not honor the request, the parent or their attorney or somebody else working with them can go to the family court judge and ask them to issue an order or writ requiring ICE to facilitate the parent's appearance. Obviously, in person would be the preferred outcome, but phone participation is an option. As Lindsay talked about in her remarks on power of attorney, any parent who is at risk of being placed into immigration proceedings should be thinking about both what they would do in terms of care for their children if they are ultimately removed, and what kind of documentation they need to gather in order to make sure that if they want to take their children with them, they can. It's good to think of these things up front in advance of an apprehension by immigration. Certainly, if a parent is detained, that is the time to immediately start working on these things, particularly if they want to take their child with them. Obviously, a child needs a passport to leave the United States, and if they're U.S. citizens, having that passport is very important for them in the future. It can be a bit difficult for a detained parent to apply for a passport for their children, but there is a process that they can follow. And again, I'll direct you to the links on the Women's Commission website for information. Most children will need a visa if they're going to live for a longer period of time in their parents' home country, and the parents' consulate can help with that. You want to gather medical and vaccination records and school records. And you also want to inquire with the parent's government as to whether there's any particular documentation, certain forms of birth certificates, for example, that might be required to allow a child to enroll in school and to live long-term in the parent's home country. Now moving on to what happens if you know a parent is going to be removed or they have been removed. It's obviously a lot easier to facilitate family unity if a child is not in the child welfare system. As I said before, children can join their parents in their country of origin. If you're working with a parent who's facing a possible removal, I would really urge you to have a conversation as early as possible about the parent's wishes. Some parents will want to take their children with them. Others will want their children to remain in the United States. And something to keep in mind in this regard is that the experience of being detained is incredibly disempowering. Parents feel like not only are they losing their liberty, but they're really losing the ability to act as a parent to their children. So having a conversation in which they can express what they want to have happen to their children at the end of their immigration case can be very empowering for the parent. It's really an important thing in terms of trying to rebuild that family and the well-being of everybody involved. Keep in mind that parents may have a sense that they are going to be removed soon, but they are not told when or how they will travel. ICE does not generally share that information. The consulate of the parent's country can sometimes help as a go-between between ICE and the family to make sure that a child could either travel with the parent, could follow them after they've been removed. And it is always worth asking ICE if they can assist with family travel. There is no policy requiring ICE to do this, and certainly ICE cannot quote unquote remove or be perceived to be removing a U.S. citizen if the child's a U.S. citizen, but they may be willing to help find a way for that family to travel together, either on an ICE flight or on a commercial carrier. But the one thing you want to remember, if a child is not in the system and you're working on family travel arrangements, is that if there is power of attorney, and specifically if there is any court-ordered guardianship arrangement, that arrangement needs to be ended before the parent takes the child. If it is not, the parent could be charged with kidnapping. As I mentioned, it's more complicated to facilitate family reunification if children are in the child welfare system. Even if a parent is removed, they have to comply with the case plan. If they don't, that plan will be ended and the case can move towards termination of parental rights. As soon as a parent or as soon as someone helping the parent knows that removal is coming, it's very important that everyone involved, the family court, the child welfare caseworker, and all of the attorneys know that the case is ending and what the parent's wishes vis-a-vis the child are. The parent can request adjustments to the case plan to make it easier to work from outside the U.S. Maybe they can extend the timeline. They may be able to order, for example, phone visits or Skype visits instead of contact visits. There are things that can be done, but you want to start early to make that happen. Of course, you need to be sure that everyone involved, from the family court to the child welfare workers and attorneys, know how to contact the parent. If the parent doesn't have a permanent place to live in their home country, they can use a relative or a friend's address as their temporary residence. Obviously, when they move to a more permanent situation, they need to be sure to notify the child welfare system. And they really ought to be looking to secure employment and a place to live. Again, the consulates can help with all of these things, and they can help make sure that the child welfare agencies in both countries are working together towards completion of the case plan. A parent can participate in family court from abroad. They have the right to. Obviously, in practice, that's incredibly difficult. On the immigration side, if a parent is eligible for what's called voluntary departure, which is not, it's not being removed. You do leave the country, but it is not a formal removal order. It can open up more possibilities for a parent to return to the United States in the future if they're eligible to do so. So a parent really ought to ask the immigration judge and immigration attorney if voluntary departure is feasible in their case. In some of the more high-profile cases, a parent has been granted humanitarian parole to either stay in the United States or return to the United States. In to participate in that family court proceeding. It is rare, and I'd urge you to talk to an immigration attorney about humanitarian parole options. You can ask the family court for more time. This would be an excellent time to try to help the parent find an attorney if they don't already have one. As a reminder, again, that should be an attorney based in the U.S. and practicing in the state where the child welfare case is open. The parent needs to communicate with the family court very regularly on everything that they're trying to do to work the case plan and participate in court proceedings. And we have heard of cases where a parent has been able to participate in court either by telephone or by Skype. Just lastly, I wanted to flag a couple of resources that can be helpful. ICE has a public advocate, and that office's mandate is to assist with issues of concern that emerge as a result of detention. So if a parent or if someone helping a parent is trying to facilitate compliance with the child welfare system from detention and isn't having any success at the facility level, you should really take that concern to the public advocate in the field office with jurisdiction over that detention facility. And there's a link here in the slides so you can find out who that person is and how to contact them. If you're not getting anywhere with the field office, you can raise that public advocate request to the headquarters level. You should have paper documentation for all efforts to contact and communicate with the facility staff, the ICE staff in the field, and the public advocate, and any outcome of those efforts. Again, consulates can be very helpful. The one caveat is if a parent is an asylum seeker, but for some reason does not want their government to know where they are, you should never be putting them in contact with their government. Sometimes there are chaplains or counselors or caseworkers in facilities who can be helpful. And lastly, particularly for child welfare folks on the phone, ICE has this online detainee locator system that I mentioned earlier. It can help you find out if someone is in detention and where they are being detained. The link is here on the slides. You'll need to have the parent's name and alien registration number, or their name, their date of, or their country of birth, and their date of birth. So I'll stop there and happy to get into more details in Q&A.
Thank you so much, Emily. Finally, we have Gretchen Kuhner from Instituto para las Mujeres en la Migración, IMUMI, who will speak about family unity challenges that removed parents are facing in Mexico.
Hi, my name is Gretchen, and I work at the Instituto para las Mujeres en la Migración in Mexico City, Mexico. Thank you for letting us participate today and for participating. I'm going to talk about some of the cases that we've seen in IMUMI of parents who have been deported from the United States back to Mexico and some of the challenges that they are facing. IMUMI is an organization that has been an advocacy organization for women in migration in a broad context. And what we've done over the last couple of years is try to identify the different kinds of problems that parents are facing on a regional level and begin working on a regional level. And the reason is that we began to see cases of migrant families, for example, a migrant family that had lived in the United States, a Mexican father, a Honduran mother, and a U.S. citizen child. And when the Honduran mother was deported back to Honduras, the Mexican father decided that he could no longer take care of the child because he had to work. And so they decided the best arrangement for them would be to send the U.S. citizen child back to Mexico, and then the Honduran woman went to Mexico to take care of her child. So in IMUMI, we found ourselves having to work a case in which we were trying to legalize a Honduran mother and legalize a U.S. citizen child so they could be together in Mexico, while the father, Mexican citizen father, continued to work in the United States. So that's just one example of the kinds of cases that we've been seeing, and what we've decided to do as a result of looking at these kinds of cases is to begin a legal clinic at the end of this year. And so what we're doing is hiring a U.S. trained lawyer to help us facilitate the kinds of cases that Emily and Lindsay were discussing earlier, because sometimes it's so difficult for parents to be able to continue participating in their child welfare procedures once they've been deported. So when we're hoping that we can help facilitate with a U.S. trained attorney from Mexico. And then we also have a Mexican attorney who's a family law attorney, and a Mexican attorney who was working on Mexican immigration issues. And so that's how we're deciding to put our legal clinic together and to work on these kinds of cases that we've seen on a regional level. Okay, so some of the types of cases and the examples of the cases that we've seen are parents leaving the U.S. with or without children in order to prevent deportation. So I think that it's important to talk about that because you all have a really important role to play in trying to help parents if they're going to leave, organize the paperwork like Emily said, and also to think about what would happen if their children did go back to Mexico, the citizenship of the children. So, for example, we've seen parents, or, well, in this case, a mother who was in a situation of domestic violence, and she was so afraid to go to the authorities that she decided to move back to Mexico on her own with one U.S. citizen child and one Mexican citizen child. And so when she got back to Mexico, the U.S. citizen child decided that he would rather be in the United States. He was 16 years old, and it was really difficult for him to assimilate. And so we were able to help her prepare the paperwork and the documents necessary, and also the custody arrangements in the United States so that her son could go back to the United States. So those kinds of cases are important to think about so that we can prevent some of these other tragedies. We've also found cases of parents deported with a child welfare case in process, which is what has been talked about already. And what we're trying to do there is connect with U.S.-based attorneys to help with those kinds of cases. But lots of times there's a lot of documentation issues that are involved there. And there have been some cases that we've seen in which the parents have been able to continue to participate in the child welfare proceedings or the family proceedings. But I've only seen a couple of cases in which, for example, a video conference or Skype interview was allowed. And in the majority of the cases, it's too confusing, the timing is wrong, the communication is so difficult that we've seen parents give up. And unfortunately, what happens is that they lose parental rights. And then finally, we've seen cases of parents who have remained in detention during the whole entire case and then are deported after losing parental rights. And in those kinds of cases, it's a terrible situation for us because there's really nothing that we can do. We can help. So what we have been doing is help to get all of the court documents so that we can at least review them and try to explain to the parents what has happened. And then also, in some of the cases in which the parents or the children are a little bit older, for example, we can help the parents register in the adoption registry in the state where the child was given up for adoption, so that at least they have some kind of hope or closure, knowing that if their children want to look for their biological parents someday, they're able to do that, because these are closed adoptions, and it's very, very difficult for the parents to understand why they can't have any communication with their children. Okay, one of the issues that we're looking at is when parents are deported, who are they turning to for help? And we found that this is one of the problems, is that parents don't know where to look for help. And so they've been going to the Ministry of Foreign Affairs in Mexico City, or sometimes the regional offices in other states. And that has different levels of success. It depends on whether the person there is willing to help them get in touch with the consular protection office or the consulate in the state where the welfare proceeding is occurring. We've also seen parents go to the Department of Child Welfare, which is the Desarrollo Integral para la Familia, the DIF offices. And usually they go there if there is a proceeding that's pending, and they are trying to get a home visit study or a home study done so that they can use that to show the court that the house where they would be living and the circumstances in which the children would be living are appropriate. They've also gone to state-level migrant protection offices, which we've seen don't have very, very little information about the situation. That's something that we're hoping to change. National or state-level human rights offices. We saw one woman who went to almost all of the UN and other international agencies looking for assistance. Local civil society organizations, either on state of origin or along the border. And along the border, there is more assistance. There's more organizations that are learning more about these kinds of cases and are able to provide assistance. And then one of the issues that has come up is that some people are trying to hire private attorneys from Mexico to help out with their child custody cases in the United States, and that sometimes can be very problematic because they promise things, or people end up paying a lot of money for procedures that actually cannot occur. Okay, so one of the things that we've also been able to do is help some with home studies that can be conducted either through the DIF social worker or a private social worker. And what we've seen are some of the complications with DIF is that sometimes at a local level, the people working at DIF think that they don't have jurisdiction to do a home study for a case that is pending in the United States. It also takes a lot of time. Translation is an issue, and we've actually found that it's easier to hire a private social worker. So when we've hired private social workers, what we've tried to do is to translate examples of home studies that we've seen in the United States, because the type of home studies and the type of questions and issues that social workers look at in Mexico are very different from those that are required in the United States. Communication challenges on all levels, but even more than communication challenges, we've also had a horrible time, or a very difficult time, explaining the differences in the legal, cultural, and socioeconomic expectations about children's best interests, in the sense that it's unfathomable for people in Mexico to understand why parental rights would be terminated just because a mother went through a red light and then was detained by immigration. So it's taken us a lot of time to try to figure out how to explain to parents what has happened, and then also to convince parents to not try to go back to the United States in an undocumented fashion to try to recover their children. We had a couple of cases in which the mothers were so desperate that they ended up trying to going back to the border and trying to cross again, and then that comes to all different kinds of risks for those parents who are trying to cross the border. Okay, so what we're going to try to do from IMUMI in Mexico is one of the parts of the project is to do research among all of the different agencies that I've talked about, to try to figure out what roles they've played, what kinds of cases they've seen, and how we can help to improve coordination. We can also eventually provide information and training to government agencies and civil society organizations in communities of origin and along the border, including the kinds of prevention strategies, because actually people in communities of origin are very good sources of communication for family members in the United States. We're beginning a communication strategy. We're asking journalists in Mexico to take a look at these cases and try to get some of the issues out in the press, because it's an issue that people haven't been talking about in Mexico. We can try to coordinate with U.S. NGOs that have cases in Mexico, and also help parents contact service providers or legal representatives in the United States. And the last slide that I wanted to talk about today is some of the things that you could do to help our organization. One of the things is that we currently have two job positions available. One is a research position to help do the research on these types of issues from Mexico, and the other one is for a U.S. trained attorney to help facilitate these cases from the Mexico City office. Also, if you could contact us if you have cases in Mexico, and especially if you have information about good practices regarding video hearings, case studies, reunification of children with parents after deportation in general. We know that that people are doing this on an individual basis all over the United States, and we don't want to spend a lot of time recreating information if it already exists. And also continue to include us in trainings and information sessions so that we can improve our advocacy work and services. Okay, so I think that's it. And if you have any questions, you can ask us.
Thank you so much, Gretchen. That concludes the presentations, and now we have about 20 to 25 minutes for questions and answers from those of you who have called in. I will actually turn it over to Rachel to explain the process for asking questions.
Hi, all. So what we're going to do is we're going to have people ask questions out loud. So to ask a question, you can use the webinar control panel box on the right of your screen. On the left-hand side of the box, you'll see a little hand with a green arrow. If you click this, it will raise your hand, and that means that we will be able to see you here and then be able to respond to your question. I will prompt you when it is time for you to respond, and I will unmute you. Please introduce yourself with your name and any organizational affiliation before asking your question, and please keep it short. Due to time constraints, we may not be able to get to everyone's question. I see that people have been asking questions in the question pane. Since if you had a question there, and you would like us to respond to it, please do ask it again by raising your hand. Again, that's on the left-hand side of the box.
We have a question from Donald Anthonyson.
Donald, go ahead if you'd like to ask your question. Donald, hello? Okay, he's not asking a question. We have a question from Judith Nord. Judith, I'm going to unmute you. You can ask your question. Go ahead.
Hi, I was just wondering if the materials are available. The presentation was very helpful, but I think the written materials would also be helpful.
Yes, we do plan to have to follow up with everybody via email with slides that were used in this presentation, and we also expect to have full audio-visual recording of the webinar available as well.
Okay, and then I also had a related logistical question. Are there lists of attorneys available in across the states who are immigration attorneys that could assist the child protection attorneys?
Lindsay, did you want to take that question?
Sure, I can. I think that if the first place to look would be if there is a legal orientation program or an organization, like a legal service organization for people in detention. And then the second would be the immigration court actually gives out a list to people that are in removal proceedings that lists low cost or pro bono or private immigration attorneys that take cases. My one worry about that is that you might be kind of making a lot of calls to a lot of voicemails, and not, those people haven't necessarily been designated to assist with these issues, but that could be a start. The other place I would look is the American Bar Association Commission on Immigration. On their website, they have a map that provides by state different immigration, either legal service organizations or other organizations that do like low cost immigration assistance. So that might be a good place to start as well. And if you want to email me after, I can provide links to those things as follow up, or maybe we can for the whole group.
Okay, thank you very much.
Mm-hmm.
We're going to also read out some of the questions that have been submitted. We had a question from Martha Matthews asking about, do parents have a due process right to participate in dependency proceedings? Here in Los Angeles, our juvenile courts are unable to get ICE to transport detained parents to their hearings, even if the parents are in a detention center here in LA County.
Hi, Martha. This is Emily. The short answer is yes, the right exists. The long answer is that it's very difficult to exercise it in practice for the reasons that you are describing. And a lot of times it seems that ICE and child welfare are quibbling over who's responsible for actually facilitating the transport, literally who's supposed to pick up and drive the parent from the detention center to the court. A couple of things that I would suggest trying. First and foremost, to take a look at the new standard 5.2 in the performance-based detention standards and try to follow the policy that is laid out there for requesting participation in family court proceedings, even if those standards are not in use at your facility yet. They will be eventually, and it's something that ICE has sort of given the green light to and said this is the process we'll follow in the future. The other thing I would suggest is if you're not getting any success at the facility level, to take that issue up to the public advocate in the LA field office, and if you're not successful there, to take it to the public advocate at headquarters in Washington. If you're still running into difficulties, would love to hear about it. It's certainly an issue that we would want to make sure we are flagging with ICE in our advocacy meetings and see if we can get a clear determination of who's actually responsible for transporting a parent, because I think that's a big part of the problem.
Great. We also have a question now from Gustavo Garcia. Gustavo, your line's open.
Yes, hello. I am in Mexico City. I am an attorney here in Mexico City, and I've recently taken a couple of pro bono cases regarding reunification. In one of them, we were successful in convincing the court via a private attorney in Pennsylvania about having the parents appear via Skype on such case regarding termination of parental rights hearings and dependency hearings. But in both cases, I've had experience once the parents are deported back to the home country, in this case Mexico. In both cases, they have the telephone and email contact information of a court-appointed attorney back in the U.S., but apparently getting in contact with a court-appointed attorney has been extremely difficult. So my question was whether or not there was some type of accountability to try to force the U.S. attorney to establish contact with the parents via telephone or other sources of communication, since it's practically impossible for them to appear or go back to meeting with their attorney at their office in the U.S.
Hi, Gustavo. It's Emily. I'm going to give this a shot, and I'm hoping that Lindsay or Gretchen may have some ideas as well. This is a scenario I've heard before. I've also heard of cases where there's a court-appointed attorney, and for whatever reason, the parent is not comfortable terminating that relationship, and therefore, even though they want to have a private attorney come on the case, that private attorney is not able to enter appearance. I think that, the issue you raise of accountability is a difficult one to crack. I would say it doesn't hurt to try to raise that issue with the supervisor, if there is one, who might be able to compel the attorney to fulfill their obligations to their client. I think it also would be worth making sure that the family court judge on the case is aware that that's happening, and see whether the judge might be willing to appoint another attorney, or if there's anything else that they can do to ensure representation. That being said, though, Lindsay or Gretchen, maybe you've got some better strategies.
This is Lindsay. I mean, this is something that we deal with in Arizona. People are appointed attorneys, and when the parent is detained, an hour and a half away from where the attorney practices, it can be really challenging to push the attorney to visit with their clients. And I think unfortunately, in some cases, a lot of assumptions are made about the parent situation without a lot of information. So I think the advice about trying to get that information in front of the judge is really critical. So perhaps documenting in writing all of the attempts that have been made to communicate with the attorney, and then sending that directly to the court, kind of like as a pro se filing. I think when talking with judges in these cases, we've been told that they absolutely want to ensure that the parents' due process rights are protected. So if there's some evidence that the attorneys aren't adequately representing their clients, that's something that the judge, first and foremost, is going to want to be aware of. But I would say, the more that can be documented in writing, we found that we can make a lot of phone calls to attorneys that might not get returned. And obviously, these are also people that are busy and juggling a lot of cases. But if they're email addresses or letters that you can send or fax, I think creating a written record can sometimes get people's attention. But yeah, those are just kind of piggybacking on what Emily said. But I think those things, that potentially reaching out to the bar where they're licensed might be a possibility as well in really extreme cases, or informing them that you're planning to do that. Those are just a few suggestions.
Thanks, Lindsay. We'll take another question now from Soraya Fata. Soraya, your line is open.
Hi, everyone. My name is Soraya Fata, and I'm a family law attorney here in Washington, D.C. I've also done a lot of policy work on this issue. I just wanted to know if legislatively there's been any effort to revise the Adoption and Safe Families Act in order to remove or limit the effects of the 15 out of 22-month time period that quickens permanency, because as I understand, it would be it seems to disproportionately affect immigrants who are detained or deported.
This is Wendy Cervantes with First Focus. Actually, at both the federal and the state level, there has been legislation introduced that would have an impact on the 15 to 22-month timeline, and that's there was a provision included within the Help Separated Families Act that was introduced by Representative Roybal Allard earlier this month at the federal level, and at the state level in California, there's SB 1064, the Reuniting Immigrant Families Act, that was introduced by State Senator De Leon, that would also includes a provision related to the timelines and trying to prevent the termination of parental rights from going into effect due to the detention or removal of a parent. And we can we'll provide additional fact sheets on those pieces of legislation with the follow-up material that we send out. We have another question now from Vanessa Crawford Aragon. Vanessa, your line is open.
Yeah, no, I think that you may have just answered it. I was going to ask about recommendations for policy that we could work on at the state level that would help address this issue.
What state are you in?
I'm in Missouri.
That's fantastic. We actually know that there are a few states that are interested in replicating what's being done in California right now. And so we, if you want to get in touch with us, we'd be happy to talk more with you about that.
Yeah, that'd be great.
And we also have a question from Celia Fonseca asking about this question. Yeah. Will we be able to access the slide presentation, and who in Mexico should I contact regarding reunification of a minor to a parent after he was deported? The slide, there will be access to the presentation, and I'm going to refer the other question to Gretchen, which is, once again, who in Mexico should I contact regarding reunification of a minor to a parent after he was deported? Gretchen?
Okay, we may have lost Gretchen.
Sylvia, if you can contact one of us after the presentation, and we'll get you in touch with Gretchen to answer that question. And we have another question now from Darcy Tromenhauser. Your line is open.
Thanks. I was wondering if you could just say a little bit more about the preventive steps around the guardianship documents and power of attorney. And I know some of that varies state by state, but I'm just curious, like, how should a parent think about that? Because obviously they don't want to be setting up those sorts of things unless it's necessary, but then suddenly you're detained and it's already necessary. So when does a parent take those steps?
Sure. Lindsay, can you take that question?
Yeah, I can give it a shot, and this is knowing that I don't have experience, immigration attorney and don't have experience with family law, but my understanding with talking with family law experts here is that that those agreements kind of can come into effect once they're filed, and so a lot of people are working like through community organizations or gatherings for people to go ahead and like prepare those things and have them ready, and keep a copy at home or keep them with somebody that you trust, so that if you are then picked up, that a guardianship paperwork can be filed and kind of go into effect. So it's more of a preventative measure. I think there are really, really serious things to think about, and I think you're raising that well. And the question that, these can be legally binding documents, and people really need to think through what it means to kind of delegate parenting decisions to people. So it's not something that I think we've tried to do too much without knowing some of those repercussions. And I would suggest one of the things we're trying to do is partner with family law experts in holding community clinics, so that people can kind of be educated about what these options are, and then work with an attorney to really talk about, are they thinking through everything, and making sure that documents are, done well and notarized, and that those options are thought through. So I think it's a good strategy and one that we should be doing more of, but I think it is important to be cautious about it, and probably the best thing to do would be to involve an attorney, either who specializes in family or immigration or some combination, so that things aren't, serious things aren't undertaken without thinking through some of those options.
Great, thanks. We have another question now from Ara Zuniga. Ara, your line's open.
Ara, are you there? Nope. We'll go to another question.
We have a question from Sandra Sanchez. Sandra, your line is open. All right. Oh.
She's not there.
Oh, okay.
We'll look at some questions that people have left for us.
There's a question about from Allison Way, where can we get information regarding VOWA, VOCA requirements?
Hi, Allison. If you're still on there, we're going to try to open the line and have you flesh that question out. We're all pretty much immigration folks here, so I'm not familiar with the acronym that you're using. Hang on one moment while we get your line open. Or Allison, if you're listening, go ahead and try to type it in, a clarification.
And if that's not possible, please, of course, just follow up after the webinar.
Meantime,
we're just scrolling through to see if there's any more questions.
if anybody has any more questions, please do feel free to raise your hand using the tab on the left.
Okay, I think that people have no more questions. Do know that there will be opportunity to follow up at a later time if you do have questions that come up following the webinar. So in closing, we'd like to thank our speakers again and give a special thank you to the Detention Watch Network and For Freedoms Fund for their support of this training. As we mentioned earlier, we'll be sending out a follow-up email to all of you with the slides used in the presentation, and we hope to have full audio-visual recording of the webinar available as well. For more information about parental rights and family unity, you can find links to the websites of the presenter organizations on the final page of the webinar slideshow. And you can also get additional information from those websites on how to get involved in advocacy efforts, both at the state and federal level, including legislative efforts, which is something that we strongly encourage you all to do. And finally, we'd like to thank all of you for joining us today. We hope that this was a useful and informative presentation, and we look forward to working with you moving forward. Thank you very much.